Welcome to the Pennsylvania Counsel Podcast.
Hey everyone, welcome in. All new episode here of the Pennsylvania Counsel Podcast with attorney James Creenan, the founder of Creenan and Baskowski. I am your host, Mike Leon. You know, Jim has been representing business owners, professionals, and contractors all across Western Pennsylvania in matters ranging from contracts, construction disputes, succession, and estate planning. Today's episode, we're going to be talking about letters of intent, why they're often misunderstood, and how something labeled non-binding can still create real legal and financial exposure. Jim, it's good to see you. Let me ask you on the onset here, when a business owner brings to you a letter of intent, it's already been signed. What usually surprises them the most about the situation?
Good afternoon again, Mike. What I really have a difficulty is just having clients sign anything before we see it or without our authorization or knowledge that things will be signed. So when we see a letter of intent that has already been signed, our clients find out that they're very surprised to learn that under Pennsylvania law, many elements of that letter of intent can be enforced against them, including some routine things like confidentiality, but also could be exclusivity. Means they won't be able to shop their deal to someone else, and the dispute resolution clauses would be binding. Several will survive. So in a way, it's very misleading for people to think that a letter of intent is just a formality or just a way to get the process started. It really can be a binding agreement depending upon how it's written.
Well, let's go into some deeper details on that. So in Pennsylvania, what parts of a letter of intent can kind of carry some legal weight, even if the document, like you mentioned, may say it's non-binding?
Those things typically that are most, that will survive even the letter of intent itself would be confidentiality, the exclusivity I mentioned, that will require the seller to maintain a ban on talking to other people about the sale of the business. So they can't go and find another buyer. Those are difficult for our clients to understand at the outset, but there have been a number of cases in Pennsylvania that say, depending upon how the language is drafted, there might be an obligation of the parties to further negotiate in good faith. So when we have a letter of intent that obviously might present a lower price than what the client would want, or could result in a lower negotiated price based upon the company's financial performance, those formulas that are included sometimes can be very difficult for the client to see how they might end up being at a disadvantage from signing a letter of intent prior to seeing legal or tax counsel.
Jim, you mentioned language on the page. How do the courts tend to look at conduct after a letter of intent has been signed, And does the behavior matter as much as the language on the page?
It does. Everything goes hand in hand when we get into the courthouse. The letter of intent language can also be accompanied by that type of conduct that the parties are trying to work toward a deal. A lot of the associated documentation between the parties, such as emails and text messages, those all weigh in on what the court can consider as to whether there was any effort beyond just trying to agree to agree. A lot of people think the letter of intent is merely an agreement to agree, whereas actually it might be the agreement itself. And the only thing that would need to be done after that is the formalized asset purchase agreement or real estate purchase agreement or commercial lease, depending upon the situation.
So, Jim, what kind of obligations or expectations can quietly form once these parties start acting as if a deal's already in place?
First thing we want to talk to our clients about is the entire process. The process can start with a confidentiality agreement, which is a separate document or part of a proposed letter of intent. And we want to make sure that documents are not shared with the other side until we have that really spelled out in a full letter of intent that's signed by both parties. Confidentiality is key. Confidentiality is the thing that we rely upon when we're going through these negotiations. The client is always going to have an expectation that their price will be met. Their purchase price ask sometimes is stated in the limited liability letter of intent, and that LLC letter of intent might also include adjustments to that purchase price that the client just does not understand.
Jim, where do you see in your experience these letters of intent creating the most trouble when it comes to, let's say, business sales or real estate deals or construction projects? Where do you see the most trouble?
Well, I think the biggest overall problem is that those documents, even if presented and not signed by both parties, that those documents tend to set false expectations for one side or the other. Those false expectations have to be cleared up through routine negotiation and through clarification of the letter intent. We want to put in language that allows for appropriate adjustments as we move forward through the due diligence process. That due diligence process can be short and sweet, or it could be a period of 6 months or more, depending upon the situation. We want our clients to really have that full understanding of that process. But really, when they have a misunderstanding about the nature of the transaction, that's going to permeate everything and result in a dissatisfied client if they've committed to that letter of intent already.
Can we go back to something you mentioned about negotiations? How can poorly defined terms in a letter of intent? We've been talking about this, but how can they affect the leverage later on when the negotiations or if the negotiations break down?
Yeah, good point. One key thing that we often build into a letter of intent, not just is the way to get the client's price that they want, but also we have to have a realistic viewpoint of how long that might take. We might need regulatory approval from the local agency or the state agency, or we might need for a real estate transfer. For a particular use, we might need approval of building plans, a site plan. Different types of commercial uses would require that they not just be a permitted use in a municipality, but if it's a conditional use, we need more time to prove our case to the applicable municipality or its zoning board or even planning commission. Those timing issues are the biggest factor that can come into play. And if we don't have sufficient time built into the process that we've agreed to, then the other side is going to be at they're going to have the upper hand. They're going to have the upper hand to say that they don't want to extend. They're going to have the upper hand to say that our client might lose hand money, they might lose a business opportunity, and they might be stuck with a bad deal.
Jim, I love asking you this question. I've had done it on previous episodes. Can you kind of share an example in both directions? A letter of intent that kind of narrowed someone's options or maybe created pressure that they didn't expect?
Absolutely. The biggest thing that we've seen recently would be just sort of a letter of intent that sets forth a basic framework for a purchase price that the client would infer to be the purchase price, but would have the opportunity for many adjustments. Adjustments based upon due diligence that would include a review of financial and tax records. And when the client sees the bottom line, and frankly, the client's going to be devoting a lot of time and effort to this transaction, that might impact the bottom line. And actually, it might result in a lower yield on the purchase price as a result of just participating in the transaction. So we want to look at what time frames and what measurements we're looking at so that we have a clear and fair look at the client's full financial picture, but also how that matches the language in the letter of intent.
Jim, as we put a bow on today's episode, for the business owner out there, they're listening to this, but they view a letter of intent as just a formality, which they shouldn't. What misunderstandings kind of tend to cause the biggest problems for them down the line?
I think number one is if they receive a letter of intent, they cannot sign it without having competent advice from counsel and perhaps their tax advisors who are in a position to review those details. Oftentimes, they will find that letter of intent has set in stone a lot of the business terms, and they can't improve it later. They can't improve it if they have a better business year, if other assets become more valuable, and they really need to focus on negotiating that letter of intent with their counsel. By doing that, they can end up with a better deal. They'll end up with a fairer deal. And oftentimes that misunderstanding of, well, it's just a letter of intent, that misunderstanding can be very expensive, which would either require the client to wait out a process of that exclusivity, or perhaps to run the risk of breaking a deal or losing some financial commitments that have been made as part of that deal.
Yeah. Jim, thanks for the time, the insights, breaking this all down. I appreciate it as always, my friend.
Always, Mike. Good to see you again, and look forward to the next one.
That's it for today's episode of the Pennsylvania Counsel Podcast. If you want to learn more about the work that Jim and his team are doing over at Creenan and Baskowski, do me a favor right now. Visit cbattorneys.com. Before you go, hit like, hit subscribe, leave a review, comment, share the episode. Someone who needs to hear it. I am Mike Leon. We will see everybody next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.